I'm Melvin Raymond, attorney and counselor at law. Welcome to Raymond Law Live. I'm sure for those of you who are employees in work that your job is very important to you. I'm also sure that you'll be interested in today's topic on today's broadcast. And the topic for today is unlawful employment discrimination. Now, unlawful employment discrimination can occur in various forms, and there are various types of discrimination which are prohibited with respect to, for instance, hiring or refusal to hire, or promotions, compensation, discharge or firing, and so forth. So all of those areas we'll be discussing on today's show. Now, there are laws both at the federal and the state level which prohibit discrimination which prohibits unlawful employment discrimination. Now, what are the types of unlawful employment discrimination? Well, unlawful discrimination, or it is unlawful for an employer to discriminate by, for instance, failing to hire or refusing to hire, or with respect to pay and so forth, against any individual with respect to terms and conditions of employment because of, one is a person's race. So persons who are a minority or others are protected from racial discrimination by the laws at both the federal and the state level. Secondly, because of religion, that's unlawful. Discrimination because of color is unlawful. Discrimination because of sex is unlawful, including sexual harassment. You may recall that we covered sexual harassment on a previous broadcast. So sexual harassment is a form of prohibited employment discrimination. Another basis for unlawful employment discrimination is national origin, also pregnancy, childbirth, or related medical conditions. You recall that we covered that topic previously on a prior broadcast. Another unlawful basis for discrimination is because of disability. That's covered by the federal law, the American with Disabilities Act, and it's also covered at the state level here in Missouri by the Missouri Human Rights Act. Now, so those are all the different bases where there may be unlawful employment discrimination. Now, as with everything in the law, there are time limits for filing charges of discrimination. Everything in the law has time limits. We refer to the time limits as statutes of limitation. For unlawful employment discrimination, under the federal law, we're primarily talking about Title VII of the Civil Rights Act. The time limit there is 300 days or so from the date of the alleged discriminatory act. Now, so it's the date of the alleged discriminatory act that triggers the running of the 300 days. That's about 10 months or so. Under the state law, the law in the state of Missouri, and also many other state laws, the time limit for filing a charge of discrimination is 180 days, which is about 6 months. So if you think that you have been the victim of unlawful discrimination, then you have that time limit to what I just talked about to file your charge of discrimination. And of course, it's a two-step process for the most part. If you think you are the victim of employment discrimination because of one of the bases we had talked about, then you have to if you go to the state agency here in Missouri, that would be the Missouri Commission on Human Rights. And at the federal level, that is the Equal Employment Opportunity Commission, better known as the EEOC. There is statute prohibiting racial discrimination for the most part, or discrimination based on ancestry, which doesn't require that you go to the EEOC. That's a law that covers only discrimination because of race and ancestry. So that's a different law. For the most part, you are governed by the 6-month or the 300-day time limit to file charges of discrimination. And once you file the charge of discrimination, of course, once the investigation is completed, then you, in all likelihood, would get a right to sue, a notice of right to sue. And at that point, that's when you can go to court and file a lawsuit for unlawful discrimination. 90 days after you receive the right to sue, that would be either from the EEOC and or the state agency here in Missouri. They both issue rights to sue whichever agency happens to investigate your charge of discrimination. Now, generally speaking, what are the remedies for discrimination under the law? That's unlawful employment discrimination. The remedies include, for instance, if you're fired because of prohibited discrimination, then you have the right, or the remedy is reinstatement to the same job or a similar job. So that's one, reinstatement. A second one, the court could order that the employer hire you if you were, let's say, better qualified, and they find that there was discrimination with respect to your not being hired. So if there's a failure to hire, then if the court finds discrimination, then the court could order the employer to hire you. The court could also order that the employer eliminate this discrimination and discriminatory practices. That is referred to in the law as injunctive relief. That's a so-called cease and desist. They tell the employer to stop discriminating and order them to do that under pain of further penalties by the court. Another remedy is lost wages or back pay. If you get unlawfully discharged or terminated by an employer, then the court can order that you get paid back pay for the wages or the compensation that you've lost. The court can also order restoration of benefits. And finally, another remedy that the court could order if you prevail in a case of employment discrimination is damages, that is compensatory damage for mental injuries, and also punitive damages. And if you prevail, the statute provides for attorney's fees. That's you get awarded attorney's fees possibly only if you prevail in an action in court. So those are the general remedies for employment discrimination that you could get from a court should you file a lawsuit based on employment discrimination, and that would be after you have filed a charge with either the EEOC or the state agency, the Missouri Commission on Human Rights. Another unlawful employment practice is covered by the Equal Pay Act. The Equal Pay Act, of course, is a federal law and it addresses unlawful differentials in compensation based on sex or gender. So the Federal Equal Pay Act, and many states do not have an Equal Pay Act, but unlawful pay differentials based on sex could be covered by sex discrimination. But in the case of the federal law, there is a specific statute prohibiting discrimination based in pay or in compensation. And the Equal Pay Act makes it unlawful for an employer to pay an employee at a rate less than the rate applicable to employees of the opposite sex. For equal work, it's got to be equal work on jobs requiring equal skill, equal effort, and equal responsibility where the work is performed under similar working conditions. So everything's got to be equal. The skill level, the effort, the working conditions, all that has to be equal in order for there to be possible discrimination with respect to compensation. If you have any comments or questions about the topic for today, please post them on our Facebook account. That's facebook.com/Raymond Law Live, and we will try and answer or get to your questions during the course of the broadcast. I would also like to mention, invite everyone to use our tool we would call What's Your Need. That allows you to tell us what topics you would want us to cover in upcoming broadcasts. If you want to tell us what you want us to cover for upcoming broadcasts, then you can email us, and the email address is mraymond attorney, that's MRaymondAttorney at SBCS South B Bell C Corporation Bell .net. Raymond attorney at sbcglobal.net. So let us know if there's a topic that you want us to cover in an upcoming broadcast. Now, with respect to equal pay, of course, there are some very important exceptions to that law about differentials in compensation based on sex. One would be if the employer, for instance, has a valid seniority system. Second, if the employer has a valid merit system, then the Equal Pay Act would not apply. And also, if the employer has the compensation or the differential in the compensation between the sexes is based on some factor other than sex. For instance, if there's some kind of measure of earnings based on quantity or quality of production, like quantity, for instance, would cover things like piecework. If that's a valid system, then that would be an exception to the Equal Pay Act. Another prohibited employment practice or another unlawful act of employment discrimination is age discrimination. That is prohibited under both the federal law and also the Missouri law. The federal statute covering discrimination or prohibited discrimination because of age, of course, is the Age Discrimination in Employment Act. The Age Discrimination in Employment Act. That's also covered by the this kind of discrimination based on age is also unlawful under the state law in Missouri, and most other states have laws prohibiting discrimination based on age. Now, who's covered under the Age Discrimination in Employment Act, or who's covered for age discrimination? That would include employees who are who are age 40 or over, age 40 and older. And what does it cover? It makes it unlawful for an employer to hire or discharge or fail to promote any individual or otherwise discriminate with respect to compensation, benefits, and so forth because of such person's age. That's age 40 and older. And as far as who's covered by the law here in Missouri, it would be employers who employ at least 6 or more persons, excluding, as we've previously mentioned, religious employers and employers of religious organizations. For the federal law, as far as age discrimination, it covers employees with 20 or more employees for each working day in each of 20 calendar weeks in the current year or previous year. Now, what are the remedies for age discrimination in addition to the things we've already mentioned? Back pay, reinstatement, or an order to hire. If the court finds discrimination because of age, then the federal law, the Age Discrimination in Employment Act, You can recover liquidated or double damages. Liquidated or double damages in cases of willful violations, and also attorney's fees. So unlike the other statutes, you can get double or liquidated damages if you prevail in an age discrimination case. Another unlawfully prohibited practice is discrimination because of disability. Disability is covered under the law in the state of Missouri, and also most other state laws, and also under the federal. There's a federal law covering discrimination because of disability. That is the American with Disabilities Act. That act dates back to the Bush era, 1993, I believe. So there is a specific federal law covering discrimination because of disability. Now, what is covered as far as disability discrimination, or what is unlawful disability discrimination? It covers employees who have an impairment which forecloses a person from a particular job and so forth. So you got to have an impairment that impacts your ability to engage in a major life activity. What is a major life activity? That would include things like walking, talking, working is also a major life activity. So you have to have an impairment from an illness or another medical condition which limits a major life activity. So employees who have a disability which limits a major life activity, the employer cannot discriminate because of that. However, and this is very important, the employee has to be able to perform the essential functions of the job that he or she is working at with or without reasonable accommodation. So if you have an impairment from a disability that renders you unable to work at all, such that you cannot perform the essential functions of the job, then you are not a qualified person with a disability, and you would not be covered by the American with Disabilities Act or the state law against discrimination because of disability. So it depends. So that's the law. Qualified employees who can work with or without reasonable accommodation. Now, the employer, if you're able to work with a reasonable accommodation, then the employer the law requires that the employer accommodate you unless the employer can show undue hardship. So typical accommodations may include, for instance, a flexible starting time or flexible end time. It could be modifications to your workstation and so forth. Those are the kinds of things that are typically the employer is required to do because it would not impose an undue hardship. And what may be an undue hardship to one employer may not be an undue hardship to another. Obviously, the larger employers have more resources to accommodate employees who may have disabilities. So that's what is an undue hardship or what is a reasonable accommodation is based on a case-by-case situation, and the court will look at case-by-case situation. So that is what happens with respect to discrimination because of disability. So those are some of the major areas of unlawful employment discrimination. If you feel that you may have been the victim of unlawful employment discrimination, then it's always a good idea to talk to an attorney who practices employment law. I happen to practice employment law. Or you can go to either the state agency here in Missouri, it's the Missouri Commission on Human Rights, or you can go to the EEOC, the Equal Employment Commission, Equal Employment Opportunity Commission, and you can file a charge of discrimination or discuss a charge of discrimination to see if what's happened to you is covered by one of the laws, either at the federal or the state level. Again, if you have any questions or comments, you can post them and we will try and answer them. So that will wrap up our discussion on employment discrimination. If you are watching this broadcast live, we would like to thank you, and also thank those of you who will watch the broadcast later for tuning in. We appreciate your time in tuning in and your interaction. We appreciate that. If you want to contact us with any comments or questions about today's topic or other topics that we've covered on prior broadcasts, or if you want to let us know what topics you would like us to cover that are relevant to your needs in upcoming broadcasts, then you can let us know. You can contact us by email. That's mraymondattorney@sbcglobal.net, or you can go to us at Facebook. That's facebook.com/Raymond Law Live, or Twitter @Raymond Law Live. So join us for our next broadcast, which will be same time, 6 p.m. Central. It will be on February 26th, Tuesday, February 26th at 6 p.m. Central Time. And remember, when you fight, know your rights.